Hello, I'm Judge James L. Kimbler from the Medina County Common Pleas Court. Today we're going to talk about incorporating pleadings into opening statements in civil trials. Civil Rule 50A allows a party to make a motion for a directed verdict at the close of the opponent's opening statement. And this is usually directed at plaintiffs by defendants, but it should be kept in mind that it can also be used by plaintiffs if defendants have set forth an affirmative defense. If such a motion is made, is the trial court just limited to the opening statement itself? Can a trial court consider the pleadings? That question was at the heart of a recent Ohio Supreme Court decision that was released on December 4th, 2013, and the decision is entitled Parrish versus Jones. And the decision was an appeal from a decision of the Court of Appeals for the 4th Appellate District. The Court of Appeals decision had held that a trial court was required to consider the pleadings when ruling on a motion made under Civil Rule 50A. This actually created a conflict between districts because the 10th District had held that a trial court could not consider the pleadings when ruling on a motion under Civil Rule 50A. It had held that the trial court could only consider the words of the opening statement itself. The majority in Parrish resolved the conflict by holding that while a trial court was not required to consider the pleadings, it may consider the pleadings. If it considers the pleadings, it has to construe them liberally in favor of the non-moving party. What is left open in the Parrish versus Jones decision is how the pleadings are to be considered along with the actual words of the opening statement. What counsel might want to consider is making a motion to incorporate the pleadings into the opening statement. Note, however, that the trial court would not have to grant such a motion. That ruling is entirely discretionary by the trial court. That is, the trial court may grant the motion to incorporate pleadings. It may not grant the motion to incorporate pleadings. And either way, according to the Parrish versus Jones decision, the ruling by the trial court would be correct. Interestingly, while I've had assistant prosecutors make a motion to incorporate the indictment into their opening statement, I cannot recall an attorney trying a civil case making such a motion. Keep in mind, though, that as I said earlier, a trial judge doesn't have to grant such a motion. Under Parrish, it is entirely discretionary. If you have any questions about this video, please direct them to the email address of judgejameskimler@yahoo.com. Please put in the subject line, opening statement video. Thank you for watching this presentation on incorporating pleadings into opening statements, and I hope that you found it information helpful.